Hearing in appeal Unger and another in substitution for Ul-Hasan against Appellants and citation.
My Lords, I appear on behalf of the appellants in this matter with Mr. Williams and Mr. Suresh. My learned friends, Mr. Amos, King's Counsel, appears on behalf of the respondent with Mr. Biarski and Mr. Rayner. My Lords, this is the appeal against the order of Mr. Justice Mostyn, dated the 2nd of July of last year, in which he dismissed the application by Mrs. Nafisa Hassan under Part 3 of the Matrimonial and Family Proceedings Act against former husband Colonel Ul-Hasan. And Mr. Justice Mostyn did so on the basis that, on the authorities that he considered binding on him, the death of Colonel Ul-Hasan precluded the continuation of that claim. And having done so, Mr. Justice Mostyn granted permission for a leapfrog appeal to this court, and permission to appeal was granted by this court earlier this year in April.
You can take it that the court has read the judgment below, the statement of facts and issues, and the cases for both parties.
My Lord, I'm grateful. In essence, my Lord, this appears to be an appeal on a pure point of law. Can, now that in fact both spouses or former spouses are dead, can this claim nevertheless be continued? Does the 1984 Act allow a claim under its provisions for financial provision ancillary to a foreign divorce to be made or continued in these circumstances? By way of introduction, my Lords, I pick up the notion of what my learned friends call the established orthodoxy. The established orthodoxy being that a claim for financial provision arising on divorce, etc., dies with one or both of the spouses. And of course, it's our submission on behalf of the appellants that there is nothing in either the 84 Act or the corresponding provision in relation to domestic divorces, the Matrimonial Causes Act 1973, that precludes such a claim surviving the death of one or more spouses. My Lords, learned friends have taken you to a great deal of authority dealing with statutory interpretation, and just at this introductory stage, if I could ask your Lordships to turn to page 1457, which is in part of the extract from Benyon Bailey and others on updating constructions. And 2/3 of the way, 3/4 of the way down that page, there's a reference to a dictum of Lord Bingham, Master Rolls, in a case called Fitzpatrick and Sterling Housing Association Limited. And that, my Lords, was a case on whether a member of a same-sex couple could be a member of the family for the purpose of rent act succession to tenancies. And you'll see the quote there: a belief which represented unquestioned orthodoxy in year X may have become questionable by year Y and unsustainable by year Z. And my Lords, it's also been said that the heresy of one age becomes the orthodoxy of the next. Now, my Lords, it used to be said that a week is a long time in politics. Of course, it's no longer. That's such a very old-fashioned thing to say. But in family law terms, it took 4 years for the heretical submissions of Mr. Mumby, Queen's Counsel, in the case of Dart, to be accepted by the House of Lords in the case of White and White, from 1996 to 2000. And that was as long as the glass ceiling of reasonable requirements to be smashed and for contribution to be fully recognised in the bigger money cases. And as we'll see, by 2006, the sharing principle, the entitlement of spouses to the fruits of the marital partnership had become fully established. So, my Lord, by way of introduction, we say the orthodoxy in this case, the notion that claims of this nature die with one or both spouses, albeit longer in the tooth than the reasonable requirements orthodoxy, nevertheless, we submit that it is now unsustainable. My lords, the issue in this case, therefore, is whether this financial order claim, and we've used that expression, albeit perhaps unsatisfactorily, but it was the best we could come up with in the circumstances, whether that claim survives the death of one or both spouses. We identified 3 sub-issues, namely, A, is the claim of such a nature to be purely personal to the spouses? B, is the claim one which qualifies as a cause of action for the purposes of the 1934 Act? And C, what exactly is going on when a court redetermines a claim following a barter appeal or set aside when one of the parties has had an untimely death? Now, of course, my lord, we dealt with some other areas in our written case, including the modern legislative framework, the evolving nature of financial order claims, how the law relating to appeals and set aside itself has evolved, and looking at some of those barter cases. I'm not going to reiterate all of that. My submissions today really focus on 6 areas. The first is to develop some of the points in relation to the evolution of the nature of financial order claims. And the second is what we've called issue C, and for the same reasons that we say it's intrinsically linked to issue A, we're going to take that then next, which is the nature of barter redetermination. My lords, thirdly, I'm going to deal with the relationship between the Inheritance Provision for Family Dependents Act 1975 and including the provision of Section 14, which allows a recently divorced former spouse to be treated as a surviving spouse for the purpose of such a claim. The relationship between the 75 Act and any financial order claim that might survive death if this appeal is allowed. My fourth area is, are Part 3 claims different? We say the answer to that is no, and I'll be saying why. And then I'll turn to the 2 major issues. Issue A, is the claim purely personal? And then lastly and sixthly is whether the claim is of a nature to be a cause of action under the 1934 Act. So my first area is the evolution of financial order claims. And there's quite a lot of material, say, in our written case about this. I'd like to boil down that history to a few key points. The first is this. Until 1963, provision for an applicant, and remember it was a wife and a wife only at that point, provision for an applicant was limited to provision during her lifetime. So periodical payments orders obviously lasted only during the joint lives of the parties. Secured provision couldn't last obviously beyond the wife's death. And where a nuptial settlement was being varied, if it wasn't being varied to take money away from an annuity given for the wife, it was providing lifetime provision for her. 1963, a lot began in 1963, but in 1963 had the Matrimonial Causes Act, which introduced lump sum provision for the first time. But before then, we say this: if the orders themselves, the actual nature of the relief itself, could not extend beyond the death of the applicant wife, that the notion that the wife's estate could pursue a claim after her death would make absolutely no sense in the context of legislation at that time. My lords, we dealt in our written case, in particular paragraph 21C at page electronic file 69, with the fact that in some circumstances, variation of settlements could be ordered after the death of one of the spouses for the benefit of the children. And that's the case of Ling and Ling that's referred to in the case of Thompson and Wachinka. So there's a distinction there already under the old law. Provision must be for the benefit of living applicant. Why? Because all forms of relief come to an end when the applicant herself die. But in fact, provision can be made against someone who is dead. We have then 1963, the provision of lump sum orders, and there's discussion in the Law Commission report that led to the 1970 Act about exactly what was going on there. But clearly in 1970, one has the Matrimonial Proceedings and Property Act. And that, we say, was a revolution in a way that perhaps the word evolution doesn't really cover it. That legislation allowed the court to deal with the contributions made in non-money terms by spouses. It is true to say that in the bigger money cases, we've already referred to Dart, that provision was still capped by this notion of reasonable requirements, but it allowed in other cases a wife to use the colloquialism who earned her share by virtue of her contributions, a new factor to be taken into account. It allowed such a spouse to gain provision unrelated to income needs. And we therefore say gradually the penny dropped that provision could be made, which not only went beyond needs, but went beyond the death of an applicant. Now, my lords, at this point, I'd like to take you to the case of Smith and Smith. We referred to it at paragraph 39B of our written case, which is electronic file 81. And Smith is reported at 1992, Family Division Reports at page 69, in the electronic file at 1014. I'll have some more to say about Smith in due course, my lords, but what happened in this case was there was an order made by the registrar at first instance, providing for, one can see this at their head note, opposite letter C on the second page of the report, of £54,000 in full settlement of her claim on a clean break basis. She then died within 6 months. The husband had sought to appeal out of time on a barter basis, and the first appeal, the appeal judge reduced the amount payable to her simply to cover the debts of the estate. And on appeal by the wife's estate to the Court of Appeal, that figure was, as you can see from the head note at the bottom there, letter H on 1015, increased to the sum of £25,000. And we'll have some more to say about the nature of that redetermination in due course. But if I can take your lordship just very quickly to the very last page of the report, it's page 78 of the report, or page 1023. And two passages. Firstly, opposite letter B, the sentence there, a wife with few or no needs, who's nevertheless made a significant contribution, has a right to recognition of that contribution. And then opposite letters, excuse me, E to F. Lady Justice Butler-Sloss says, in my judgment, it matters not where this money goes, whether it goes to the daughter, whether the wife left it to charity. It is a matter for her and her estate, because she has, by virtue of her contribution during the marriage, earned the right to provision which will endure and be for the benefit of her beyond, and her estate beyond her death. And my lords, that position was developed in the case of White and White. And if I can take your lordships to White and White, it is Authorities tab, forgive me, it's in the secondary bundle, at tab 86, and it's electronic file number 3237. And the particular passage that I rely on there is at page 3250. There's a heading, the next generation, and the orthodoxy prior to White was that it was not legitimate, opposite letter F, to take into account an applicant's wish to be in a position to make provision by will for their adult children. Lord Nichols, when he says he agreed with that proposition to a strictly limited extent, was perhaps being like the editor in Scoop, in the sense that he profoundly disagreed with it in my submission. And one can see, he says, opposite letter H, a wife's wish to have money so she can pass on some to her children is every bit as weighty as a similar wish by the husband. And into the next page, you can see a paragraph which begins, in my view. He says the correct approach is that a claimant wife's award should not be confined to housing needs and the diminishing fund of capital earmarked for living expenses, which she uses up exactly on cue on her date of actuarial death. So absolutely endorsed by the House of Lords in White is the notion that provision can endure beyond the death of an applicant. My Lords, my next point in relation to this area, of course, we say that this notion is fully developed by the decision of the House of Lords in Miller-McFarland and the birth of the sharing principle. Well, Lords, I'm not going to take your Lordships to that, but the language changes, as I've already said. We have reference to a partnership of equals, and in so doing so, there's reference to R&R, the case which got rid of the marital rape immunity. There's the language of entitlement, the idea that both spouses are entitled to a share of the fruits of the marital partnership. And that is why we mentioned the case of Richardson in our written case. We'll come back to it in a moment. That's a case where a wife's award was based predominantly on a sharing basis, then it didn't matter that she died soon after the order. That did not undermine the basis of the order. So, my Lord, we've made great play of the fact that the nature of the values which underpin the discretionary award have changed. And of course, they have changed beyond all recognition. But, my Lords, it would be a mistake to say it's only about quantification. Yes, now the award is quantified with very different principles than they would have been even in 1970. But that would be to ignore, my Lords, the real change, which is the nature of the relief itself. Lump summed for the first time in 1963, and in the 1970 Matrimonial Proceedings and Property Act, which is later consolidated into the 1973 Act, we have for the first time property adjustment powers. A provision as a result of that legislation is no longer limited in time for a period whilst the applicant is still alive. Provision from that point onwards is one sum which can be made, which endures beyond death. And my Lords, I say that the respondents themselves acknowledge this at paragraph 74 of their written case. That's at electronic file page 142. In tracing the development of the legislation, at paragraph 74, they refer to Law Commission report number 25, which was the report which gave rise to the 1970 Act now consolidated into the 1973 Act. And they describe that report as making specific recommendations for the seismic change brought into English family law by the 1970 Act. And we say they're right to describe it in those terms. The plates had indeed shifted, and it's the combination of those two factors, the nature of relief claiming, and latterly the approach to quantification, that we say is relevant to why the established orthodoxy is no longer sustainable. So, my lords, I'll move on to my second area for today, which is what we have classed in the written case issue C, which is the nature of the court's redetermination of a financial order claim following a finding that there has been a so-called barter event consisting of untimely death. And, my lords, in relation to this area, I wish to make 5 main points. The first is that the nature of redetermination does not depend on why the court is allowing the appeal or setting aside the original order. The nature of the redetermination is not dependent of the nature of the barter event or other challenge to the order. My lords, the second submission, which I'll develop in a moment, is once that original order has been set aside, the original application for a financial order is now live and at large. My lord, the third submission on this point is that it doesn't matter which route you use to get there. It doesn't matter whether it's a set-aside or an appeal. The fourth is, as we said in our written case, that the courts already have, in these cases, made orders in favour of, and indeed against, dead individuals or indeed their estates. And then fifthly, my lord, the fifth main submission in this topic is that there is nothing special about barter appeals. They are, we say, just like any other kind of appeal in the nature of redetermination. So, my lords, the first topic there, or first submission there, is that redetermination is the same process, whatever the ground for setting aside. I observe, my lords, that we didn't include the actual rules or practice direction which govern setting aside, but they are in the materials. If your lordships turn to page 2482, and the decision of Mr. Justice Moskin in CB and EB, the relevant provisions are set out in that case. The issue in that case was whether the power to set aside was confined to the previously recognised grounds, or whether it was governed by some more unbounded discretion. And at page 2491, opposite paragraph 47, Mr. Justice Motsin sets out the text of Rule 9.9a, which was introduced in 2016. The first thing to note, my lord, in sub-rule 1 is that the definition of financial remedy order includes orders made on divorce under the 1973 Act and includes orders made under the 1984 Act. So the scope of Rule 9.a extends to both an application that we're dealing in this case and an ordinary domestic divorce ancillary relief claim. And what your lordships can also see at sub-rule 5 is the instruction that where the court decides to set aside a financial remedy order, it shall give directions for the rehearing of the proceedings or make such other orders as may be appropriate to dispose of the application. And my Lord, on the next page, we have paragraph 48, which sets out part of the supplemental practice direction, paragraph 13.5, and that sets out some of the grounds. So typically, orders are set aside on the basis that a party failed in their duty to give full and frank disclosure, such that the early order wasn't properly made. There are, as we'll see from Richardson, certain types of mistake that can allow an order to be set aside. And then Roman numeral 4 in that list is one definition of what is commonly known as a barred event. My Lords, the other part of the practice direction which I want to take you to, again, is not directly in the bundle, but it's also in another authority, which I'll take you to now, if I may, and that is the case of Goodyear and Goodyear, and that is at page 2509. And this is a decision of His Honour Judge Farquhar dealing with an application to set aside a pension sharing order where the wife, who was the recipient of a pension sharing order, an order which carves out rights from the other party's pension and transfers those into a pension scheme of the applicant, where the recipient of that order died a few months after the order was made. And in that case, the judge held that because the order had been based on both a mixture of sharing and needs, her death was a barred event, and he made a fresh order. At page 2532, paragraph 56 of the judgment, he sets out, that His Honour Judge Farquhar, another part of the practice direction. And your Lordships can see there the notion that just as on an appeal you have to make good your grounds of appeal, but on an application to set aside you've got to make good your challenge to the initial order. And then once the court has decided that there is a basis for setting aside, the court has a full range of case management powers and considerable discretion as to how to determine the application to set aside. There is the ability to strike out or summarily dispose of that application to set aside. On the next page, one can see the discretion as to how then the court goes about if a ground is set aside, a ground is established rather. Ordinarily, it says, 5 lines down, the court would give directions for a full rehearing to redetermine the original application. However, if the court's satisfied it's got sufficient information, it can redetermine there and then. And we say that practice direction, albeit only a practice direction, albeit simply the rule maker's view of what the procedure intended, nevertheless is accurate. There's no distinction in either the rule or the practice direction between different types of grounds giving rise to application to set aside. So, my Lord, that's my first point, that redetermination is the same process, whatever the ground for setting aside or appeal.
But in practical terms, on a redetermination, would you have a redetermination as to what contribution a wife had made to the build-up of finances? Or would you be bound by the decision of the judge who initially gave judgment?
My Lord, I think the answer is it depends. I mean, the practice direction does say there's considerable discretion. Ordinarily, on any appeal, if a trial judge has made an error, an appeal court corrects that error and sends it back for redetermination, one wouldn't ordinarily expect, unless, for instance, findings of fact have been set aside, the whole thing to be done all over again. The idea would be to correct the error. But the nature of financial remedies, as we'll see, is that things may change. The financial circumstances may change. And so we say that it is a complete redetermination, albeit that very often the shorthand way of doing it is, well, what would the judge have done at the time of the original order if he'd known that Mrs. Smith only had a few months to live. We say that's simply a shorthand for the redetermination. In other cases, events may occur which mean that it's got to be much more rigorous than that. But one wouldn't ordinarily expect a party who's, for instance, raised an issue before the first tribunal to be able to run that issue again unless there's been a particular comment on that in the application set aside or the judgment on appeal. So the second point in this topic is the idea that once the original order has been set aside, the original application is now at large. And we say that that's the understanding of the makers of the rules and the practice direction. The order has gone. The application is now live again and needs to be determined. And we refer to this in our written case at paragraph. First of all, it's a point made in the course of what I call the ITS case. That's the Independent Trustee Services and GP Noble Mrs. Morris intervening case. That's at EF 2641. And we deal with that in our written case in two places. But there is, in that case, quite a complicated situation where a consent order had been made for the financial provision. Mrs. Morris then alleged that that deal was tainted by Mr. Morris's non-disclosure, and that application succeeded, and her claim was, as we'll see, we say, at large. In the meantime, Mr. Morris was sued for misappropriating trust monies, and a claim for dishonest assistance was made against him. And the issue was Mrs. Morris even entitled to keep what she had received under the first order? My Lords, the particular passage I rely on here is at paragraph 124 from the judgment of Lord Justice Lloyd at page 2683. Give me. And my Lords, at the end of paragraph 124, the notion here, I think, is what Lord Justice Lloyd is saying, is that someone who applies to set aside the non-disclosure and establishes that the assets were greater than was originally envisaged expects to get more because there's more money, the pot is bigger. But Lord Justice Lloyd says, well, that is, in all probability, at the end of that paragraph, opposite letter D, but he then says events might intervene to alter that position. And he says, to take only two examples, Mr. Morris might have died in the meantime. And we say, of course, that's him going along with the conventional or established orthodoxy, or might have become bankrupt. Mrs. Morris, he says, took the risk of either of those events, or indeed of any other factor which might affect the outcome of application. And in the next paragraph, paragraph 125.
I'm very sorry. I've just got a minor problem with my mouse, which is making it difficult for me to move around. I thought it might just be easily solvable, but I'm afraid it doesn't look as if it is.
Right.
I'm sorry.
I think then we should probably adjourn for 5 minutes to allow this to be solved. Given that we are dependent now on electronic documents, it is important that all of us have access to that to which you refer. The court will adjourn for 5 minutes in the hope of solving this technical problem. I'm sorry for the inconvenience.
That's all, my Lord. My Lords, I was dealing with the second topic in this area, that once an order has been set aside for some vitiating factor, the original application is now at large. Of course, in paragraph 125 of the judgment of Lord Justice Lloyd in the ITS case at EF 2683, he continues to refer to, for instance, the risk of bankruptcy or indeed the risk of death, and talks about potentially another remedy under the 1975 Act. The particular passage I rely on is the one essentially beginning, however, either way, the position would have been at large, and it could not necessarily be assumed that she'd have been able to retain all she'd received under the original order. And
So whereabouts on page?
forgive me, my lord,
Letter F.
it's
Letter F,
just
yeah.
above letter F,
Thank you.
about halfway between E and F. However, either way, whilst she would have been likely to hang on to what she'd got under the first order, it was not impossible that she would have to give that up. So the point we make there is whatever the nature of the challenge and whatever the route of challenge, once the original order has been set aside, it's all to play for. The original application is at large. The third submission in this area is that there's no difference between the route. There's no difference between appeals or set aside. We've set out at some length the labyrinthine progression of how it comes to be that orders can be set aside by first instance tribunals and the reasons why that change was made in 2016. But we say whichever level is dealing with it, whether on appeal at a higher level or at set aside or at the same level, the court first has to decide whether a ground exists to reopen. As we've seen already, if there is such a ground, the court can then redetermine or give directions. In an ordinary appeal after a trial, one would ordinarily expect an appellate court to send back down to a first instance decision, a first instance tribunal, unless it can redetermine itself. That option is rarely pursued in a barred appeal because usually there is sufficient information to redetermine. But we've given an example, my lords, at paragraph 50 of our written case, or a hypothetical example, I should say, in our written case at page EF 89. Now, Richardson, we will come on to in a moment or two, is the case where there were two challenges to the order that had been made, whereby Mrs. Richardson got just under half of the total pot. One was her subsequent death, and the second was this emergence of a claim not covered by the insurance against what had been their business. And possibly better to look at the beginning of our paragraph 50 at the bottom of 88 on our written case, where we summarise what happened. The lump sum that had been payable to the wife and indeed was payable to her estate was reduced by an amount yet to be determined, being effectively half the sums that were going to be incurred in defending or resolving the claim against that business. And of course, Richardson, although it was an appeal at the time, would now be a set-aside case. Sometimes courts make what is often called a contingent lump sum, so the amount is unquantified or unliquidated and to be determined with reference to a future event. But one of the options the court might have had in that case would be to await the outcome of that claim and then send it back down for a first instance tribunal to deal with that. And we say it would not have mattered that she had died for that to take place. So we say in effect that this is no different to any other kind of appeal. An appeal court which is not dealing with a pure issue of law has to decide whether any ground of appeal is made out. If not, the appeal is dismissed. And if there is a ground, then the appeal court needs to decide what to do, whether to redetermine itself or to send it back down to a first instance tribunal. And we therefore say there's absolutely no difference in the outcome, or the nature of the court's powers are not dependent on whether there is a appeal or set aside. My Lords, the next topic in this is the fourth one, which is the notion that courts have already made orders in favour of or and indeed against dead persons. We saw the case of Smith and Smith a moment or two ago. That is at electronic file page 1014, and we had already looked at the big picture in that case. First instance decision, 54,000 to the wife on a clean break basis, her death within 6 months, the circuit judge reducing her award right down, and the Court of Appeal putting it back up to 25,000. It's important to note, of course, that the first instance decision made was by the registrar, who didn't become a district judge until I think a year or two later, when the name was changed. And then there were two lots of appeals in this case. The first thing I emphasise about this case is that the appeal to the Court of Appeal was an appeal by the estate. So the estate effectively is being brought in to be the respondent to the living husband's application to reopen for leave to appeal out of time. And it is the estate effectively that appeals the first appellate determination. And it's their appeal, and their appeal was allowed. We've already seen that the court, Lady Justice Butler-Sloss, considered that the judge was wrong to limit the claim or the award to the wife and her estate simply by reference to the debts of the estate. And so we have that passage at the bottom of EF 1021, letter H. And she says she rejects at that point the starting point of equal division of the assets. Well, this is 14 years or 8 years before White. But she says the correct approach is to start again from the beginning and consider what order should be made on the facts before the judge. Now, of course, she means in this case before the circuit judge, not the trial judge, because the trial judge was the registrar. And so the court there is not reopening the facts. It's saying these were the facts as known to the first appellate court, and we're going to review that determination made by the first appellate court. And at the bottom of that page, the very last line, she says, the issue now is to the right order to be made between the spouses where the wife is known to have only 6 months or so to live. But that is not, as we'll come on to say, not going back in time. It is making an order now, but with the knowledge that Mrs. Smith in that case had 6 months to live from the time of the original order. What then does that mean for how the court approaches the well-known checklist in section 25.2 of the Matrimonial Causes Act? Well, we can see how Lady Justice Butler-Sloss deals with that, having set out those criteria between letters D and F. She sets out what the pot is. She then says, subject to the brief period before the death of the wife, the husband alone has to be considered under A and B. And so we get there some guidance as to how to construe these checklist factors, which on the face of their text might be said only to apply to living persons. As I say, we say it's not going back in time before death. It's not a hypothetical exercise. It is an exercise of discretion, applying all the factors in the light of the facts as known to the court now. And we've already seen that doing so on the next page, the award of 25,000 was justified with reference to Mrs. Smith's contribution to the marriage.
Why is the husband's income earning capacity limited to the period prior to death?
Forgive me, my lord, this is the passage at
Yes, at F.
77F. Forgive me, my understanding of that passage is that
The husband is still alive.
yes, so there's two periods. There's the period before the wife's death where both of them have to be considered under A and B, and then after the wife's death,
Just the husband.
only the husband.
Yeah, so it's in fact saying that you consider the husband's position after the death and his alone at that point.
Because she goes on,
in regard to what the factors A and B are. Yeah.
and she goes on, forgive me, my lord, in the next sentence to say he's 65 nearly, and he's due to get his state pension soon. So she's considering the husband's position both now and in the foreseeable future. But of course, there's nothing to consider after her death for the wife, and so limit necessarily under A and B.
Well, nothing to consider under A and B.
Yes, indeed.
Well, it's inherent anyway that not all the factors may apply to either or both particular individuals.
Indeed, my lord, absolutely.
Somebody might not have any earning capacity if they're disabled, for example.
My lord, yes. And so then we have, as I say, the language as one would expect from any tribunal making determination on the following page, opposite letter E, that's 1023. The very last sentence of that long paragraph, taking all those factors into account, in exercising discretion under Section 25, I would award the wife 25,000. So that's an order, we say, in favour of someone or the estate of someone who's now dead. The second part of the submission is the order made against someone who is now dead or their estate. And the best example of that is the case of Reed and Reed. For your lordship's reference, we've dealt with that at paragraph 48.
So can I just reiterate the point that I think may be important? So section 25.2, despite using the language each of the parties to the marriage, clearly is being used in situations where one or either of the parties has died.
My lord, yes.
Yes, thank you.
And accommodations are being made to deal with the fact that where it doesn't apply to one, or that only applies to one for a particular period, that's with a perfectly permissible exercise of discretion and construction of those checklist factors. So I say, my lord, I'm going to move on to orders against dead people or their estates, and say the best example of that is Reed and Reed. We dealt with that, for your lordship's reference, at paragraph 48 of our written case. And the authority itself is at electronic file 939. Forgive me, it starts at 937. The decision reported at 2004, volume 1 of the Family Law Reports, at page 736, a decision of Mr. Justice Wilson towards the end of his first part of his career as a family division judge, before he went on to greater things. He held in the facts of that case that the wife's death shortly after the order was made, or unexpectedly early death in that case, was a barda event. And what had happened in terms of the disposal originally, one can see at paragraph 6 of the judgment, and that is at page 939. Very commonly, a matrimonial consent order will be a mixture of agreements and undertakings recited before the curial part of the order, and then you'll have a section of the order that will say it is ordered that, and then that order will contain lump sum orders or other orders and dismissals. And here, the only order itself was a dismissal on the basis that there was an agreement that the house was going to be sold and the net proceeds divided 40% to her and 60% to him. And having found that her untimely death was a ground for reopening, the disposal or the decision made by Justice Wilson can be seen at paragraph 28 at page 946. And you'll see that the second sentence of that paragraph, he says, well, there was what he calls a prefatory agreement, effectively an agreement recited in the preamble to the order of the division of proceeds. And so what he effectively did was to set aside the dismissal and make a lump sum order from the wife, now deceased, to the husband out of the monies that were otherwise due to her under that agreement. So, my Lord, that's what we say about the orders being made, and there are other cases, but those are the two clearest examples. The last topic on this, last submission on this topic is the notion that barred appeals are nothing special in that sense, that there's nothing different going on in a barred appeal to any other kind of appeal. This is, to deal with this notion that there is some kind of travelling back in time. Often it is said, what would the right order have been at the time of the original order if it had been known that the wife had only 6 months or whatever it is to live? And I say that is simply a convenient shorthand for the redetermination. So we've seen from the case of Smith and Smith that the wife, the person who had now died, their needs would only be relevant for the period between the order and their now known date of death. And in many cases, there are simply no new factual developments that require any updating to be done. One can, as it were, notionally travel back in time because one isn't really travelling. There's nothing to change. Now, my lords, the high watermark of this notion is the case of Barber, which is tab 7. It's not the Barder case, it's a Court of Appeal case, and it's at page 633. My lords, that's a decision of a two-judge Court of Appeal where the word is of hypothetical is used, and I just want to make some submissions about that. An order where I think this is the case where the wife was expected to live 5 years and died less than 3 months later, and the court reopened that award. If I can take your lordships to judgment of Justice Glidewell, and particularly at page 636. Justice Glidewell refers to the case of Smith and Smith. He refers to the passage I've already cited, the correct approach being to start again. That's the second, about more than halfway through the second of the passages cited on that page. The correct approach is to start again from the beginning and consider what order should be made on the facts before the judge. And of course, bear in mind that the judge in that case did not mean the original tribunal that had made the order before death. And he then records the agreed submission of counsel that the proper approach is to put oneself in the position of the judge sitting before the wife's death, but knowing as a certainty the wife would then die. And that may be, as I say, a convenient shorthand for redetermination in cases where there is no major development in the facts. But even on the facts of that case, my lords, there were two developments that Lord Justice Neal refers to. That's at page 640. So we know already that the dead party will have no income earning capacity and financial needs after their death. But you also have the additional factors in the second paragraph, the one that begins looking. Two changes Lord Justice Neal refers to. One is that the husband's going to take full responsibility for the family, so he's going to be making a greater contribution to the welfare of the family. And the second one is that there is this additional money that has come about as a result of the wife's death as a result of an insurance policy. So one isn't really going back in time, one's determining matters on the events now known, with potentially greater resources available as a result of that. My final example on this point before we move on is the case of Richardson. My Lords will say we deal with that in our written case at paragraph 40. We've referred to it in passing already. And the authority is at electronic file 947. To say, my Lords, in this case, the Court of Appeal had to deal with an appeal out of time on two bases. One was the wife's subsequent death, and secondly, the discovery that the business was not covered for a potentially very large claim against it. And there was some discussion about the nature of the second, but ultimately it was agreed by the Court of Appeal that that was a common mistake. The parties assumed that the assets were going to be 2 or 3 million more than they in fact were when that liability was factored in, and so it wasn't truly a barter event. Now, my Lords, the death of the wife in this case, following her receiving about 5.2 million, was not a barter event. She was getting an award on the sharing principle. She was entitled to the fruits of the marital partnership, so it made no difference that she died shortly after the award was made. As I say, it wasn't the only challenge, because the lack of insurance cover was seen as a vitiating mistake. My Lords, if I can take you to page 964, the Lordships will see, having got through the discussion as to which were vitiating factors and how they dealt with it. Paragraph 75, the Court of Appeal's disposal was that there was some money that was still due to the wife, a second tranche of money of 1.6 million, and that would be reduced by 1/2, effectively, of the sums that were going to have to be paid out in defending and resolving that claim. So, my Lords, I ask your Lordships to consider a slightly different set of circumstances. We know that in this case, Mrs. Richardson's death did not amount to a barter event, because her claim was based on the sharing principle, and so it made no difference. But what if it had? What if her award was based on needs? For instance, that the source of the wealth was not in fact the fruit of the marital partnership, and her award was assessed at 5.2 million based predominantly on need. Well, her death would have been a barter event. So I ask the question there, do you simply, when you've allowed the appeal or set aside the original order on the basis of that event, just travel back in time and ignore the fact that we now know that there's 2 or 3 million pounds in the pot, less in the pot? Of course one doesn't. One redetermines this case on the information that we now know, that instead of the total assets being in the region of 10, 11 million, they are in fact going to be something like 8 or 9. So one has to, I say, take all those authorities that say, what would we do if we'd been in a position of a judge but knowing the wife has died, as simply a shorthand that will work in some cases, but it won't work in all cases. One is looking, I say, at the situation now, and making allowances for the fact that one of the parties is dead. So, Lords, on this point, the second point, we say that a redetermination following a barter event is a determination of the original application. Courts, therefore, have been making orders for the benefit of and against the estates of dead parties. And we therefore say if this can be done post-death on a barter, appeal or set-aside, where the original claim is again at large, we say of course it can be done on an original determination where the claim is by definition at large. My Lords, my third topic was the relationship between the 1975 Act, the Inheritance Provision Friendly Defence Act, and financial order claims. And here I want to develop and expand the points we make at paragraph 56 of our written case, and in particular those, that's at electronic file 93, and to deal with some of the suggestions or notions put forward on behalf of the respondents. They include why go to the bother of enacting section 14 of 1975 Act if financial order claims in fact survive death. Section 14 is a provision that says if you're recently divorced, you can, if in the last 12 months between decree absolute and date of death, you can be treated as a surviving spouse. Why extend the right to apply under the 1975 Act to those divorced overseas if Part 3 claims survive death? And the suggestion is made that Parliament would not have intended unnecessary duplication. So my submissions on this point have four main points. We say that the ability to pursue a financial order claim and the ability to bring a 75 Act claim are not coterminous. They don't completely overlap. And we'll see why that is, not just in the facts of this case, but other cases in a moment. Secondly, we say that section 14 is a sticking plaster. It's only a partial provision and doesn't help every deserving litigant. Our third point in this is that there's absolutely no reason why family law remedies, i.e. financial order claims, and succession law remedies, the 75 Act claim, should not overlap. And then the fourth point in this area is the fact that the development of development of the Inheritance Act claims is not inconsistent with financial order claims surviving death. So, my Lords, the first point there, first submission, is the idea that the circumstances in which you can bring a 75 Act claim and or pursue a financial order claim are not identical. Of course, under the 1975 Act, the deceased must have died domiciled in England and Wales. The current rules for bringing divorce proceedings, my Lords, it's not in your bundle, not in the volumes, but it's in section 5.2 of the Domicile and Matrimonial Proceedings Act 1973. And this is legislation that's been changed a number of times since it was originally acted, obviously to cope with the introduction of the Brussels regulations dealing with divorce, and then obviously since exit from the EU, it's been amended. There are 7 limbs that deal with jurisdiction in divorce. The first 5 are basically based on habitual residence of one or other party. The 6th is the domicile of both parties, and the 7th is domicile of one party only. So there are many circumstances, we say, in which there will be the ability to pursue a divorce in this jurisdiction and therefore apply for financial orders on that divorce, where a respondent will not be domiciled in the England and Wales if they then die. So there's potentially a great many cases where there is simply no overlap of those two provisions. In addition, my Lords, there are cases where, for whatever reason, a person might might not be able, forgive me, to pursue a divorce in England and Wales. My Lords, the decision in the case of Villas number 2 is in your bundle at tab 26, and it's electronic file 1053. The decision in that case of the Court of Appeal deals with a number of issues about the construction of section 27 of the Matrimonial Causes Act. 27, my Lords, is nothing to do with financial orders. It is a freestanding claim within marriage for maintenance, and the Court of Appeal were dealing with that, the issues in relation to that. But if I can ask your Lordships to turn to paragraph 15 and 16, because the facts of that case potentially give rise to one of the points, an illustration of one of the points I'm making. The parties suppose...
What page is it?
Forgive me, 1056, my Lord. One can see that the parties, in fact, the parties got married in England. They lived all their married life in Scotland, bar 1 year. From separation, Mrs. Villas moved to England, and she began divorce proceedings in England and Wales, and the husband began a divorce writ in Scotland. And there are conflict of law rules that govern competing divorce proceedings in England and Scotland, and Mrs. Villas was caught by them. So the English petition was stayed under those provisions. Now, if one takes this scenario and just tweaks it a little bit, if assume again that both parties were domiciled in England and Wales, and the Scottish writ proceeds to decree in Scotland, and suppose again that there's no financial provision made in Scotland for whatever reason, two things arise from that. Once a party is divorced in Scotland, they cannot bring a Part 3 claim in England. And the reason for that is Scotland is not an overseas country for the purposes of Part 3. But the second point is, assuming the husband is domiciled in England and Wales, she can bring a 75 Act claim. And the definition of former wife includes not only those who are divorced outside the United Kingdom or outside the British Islands, but also divorced in any part of the British Islands. So if, in a hypothetical example, someone in the position of Mr. Villas had died in England and Wales, the fact that Mrs. Villas or someone in her position could not have proceeded to get financial orders from an English court would not have prevented her from invoking the 75 Act. And indeed, she could ask to be treated as a surviving spouse under Section 14 if the dates lined up in her favour. So the point we make here is simply this, that when Parliament in 1984 both enacted the provision to make Part 3 claims, but also to extend the right to bring the 75 Act claim to those divorced outside England and Wales, we say that's not a choice to confirm the orthodoxy. It is simply a decision to allow all former spouses, wherever they're divorced, the right to apply under the 75 Act if the deceased had died domiciled in England and Wales. And of course, the classic example of someone where the right to pursue a financial order claim doesn't overlie with the 75 Act is both a claim under the Matrimonial Causes Act or, as in this case, Mrs. Hassan's claim, where the respondent, as I say, died and was not domiciled in England and Wales. So there's no congruence between those sets of circumstances.
So you're saying that the inclusion of the 1984 Act's amendment of the 1975 Act was addressing a mischief because that same Act amendment of Part 3 didn't cover the full ground.
My Lord, yes. I mean, if one looks at the wording of section 25.1, which is the amending provision, it's EF 549. So I think we've got the full text of the original version of the 84 Act, and yes, it's at page 549. One can see the third line, being amendments designed to give to persons whose marriages are dissolved or annulled overseas the same rights to apply provision under the 75 Act as persons whose marriages are dissolved or annulled under the 73 Act. So what it's doing is making universal the right to apply under the 75 Act where someone dies domiciled in England and Wales to all persons, regardless of where the divorce or annulment took place. And so that's the. I mean, it tells you what it's trying to do in the wording of the section. So, my Lord, we say that there's no duplication because there's no congruence between those two sets of circumstances. My Lords, the second topic here is
trying to work through the. In order to be treated as a surviving spouse, you've got to bring the claim within a certain period of time.
My Lords, yes.
But you could bring a claim as a former spouse, in which case you'd be restricted to maintenance.
My Lords, yes.
And the nature of the right then depends upon when you bring the proceedings, basically. And
the nature of the right, my Lord, depends on whether the death took place within 12 months of the divorce becoming effective. And we say, moving on, if I may, my Lord, that this is the point we make. The second point, that Section 14 is a bit of a sticking plaster because the assumption made is that you'll be able to bring your claim, or your divorce is unlikely to be delayed because the financial order and the divorce are under the control of the same person. And we say that the timing of the divorce in England and Wales is not necessarily under the control of the person seeking financial orders. And for a variety of reasons, it can just be an accident who is the petitioner in the divorce suit and who is the applicant in the financial remedy application.
Sorry, I'm having some difficulty probably because I'm not as familiar with the legislation as obviously many here are, but what was, if I assume you're coming on to submit that the 1973 Act claims, or at least certain of those claims, can be made notwithstanding the death of either party?
My Lord, yes.
If that be right, what function did Section 14 of the 1975 Act fulfil? Why was that needed?
It fulfills a limited function in cases where the respondent died domiciled in England and Wales, and secondly, where there is just that 12-month gap between that. And I say it fulfilled the function of this.
So could you go over them again just to make sure I got them down? It had a limited function.
It fulfilled the function, firstly, of helping those where there was a death of the deceased within England, domiciled in England and Wales, and secondly, where there was just a less than 12-month gap between decree absolute and the date of death.
And it helped them how?
In the sense that, notwithstanding that they have not yet been able to pursue their financial order claim, despite the divorce, they can be treated as a surviving spouse. They can be seen to get provision that would recognise a sharing claim because they're not limited to maintenance. They're not limited to simply income needs. Their contribution can be recognised in that case. A former spouse claim under the 75 Act is limited to maintenance, my Lord.
But why can't the 73 Act give them all that already on your
Indeed, my Lord,
interpretation of it?
we say it does. Section 14 is enacted against an assumption that the orthodoxy that had applied before the 1970 legislation was still valid. And the passage in Law Commission Report 61 says, we think that there are these people who are going to have the death of the respondents supervening between being able to pursue their claim all the way, and if it's through no fault of their own, we should give them that protection. But I say, my Lord, it's based on an assumption that the established orthodoxy survives. It, of course, might be seen in one context as a way of dealing with a situation where the law might be seen to be uncertain. If Dest had been decided in 1972, Law Commission report was published in July 74. Dest might have been appealed. Another High Court judge might have come to a different view about the nature of the surviving claims. So if you're concerned that a 1973 Act claim might, in accordance with the established orthodoxy, die with the death of the parties, then Section 14, as it were, ensures against that risk. So I say it's simply based on an assumption.
But is the 84 Act based on the same assumption?
My Lord, no. And I say that the 84 Act, the point that I've just been taking you to, all that is doing is extending the right to apply under the 75 Act, provided the respondent died domiciling in Wales, to anybody, regardless of where they're divorced. And as I say, that's clear from the wording in Section 25(1). And I'll come on to that, if I may, in a moment, my Lords. We say that Section 14 is equally consistent with a legislature that is uncertain about the existing state of law and how the seismic changes enacted by the 1970 Act might affect the prevailing orthodoxy, as expressly seeking to endorse it.
But was there any material that would have led to that uncertainty? Was there a single decided case?
My Lord, note, I accept that. There's no, and the only decided case was the decision of a first instance judge, Justice Ormerod, in 1972, the case of Dest. Now, we say his reasoning is, with respect to him, wholly flawed, but nevertheless, and even at the time it was wholly flawed, it becomes more obvious now we have the sharing principle, but even at the time we say it's wholly flawed.
Sorry, I'm not quite sure I understand your precise submission. I understood you to be trying to make the point that we can't take it that there was an assumption when this piece of legislation was enacted that the orthodox law was being assumed to be correct.
Forgive me, my Lord. I think if I said that, I misspoke. Law Commission report is definitely based on the assumption that the death of a party would be a supervening event. It would prevent a financial order claim being pursued.
Right.
And that was the background to which Section 14 was recommended. And I say that's equally consistent with the legislature being aware that perhaps the orthodoxy might not be continuing, and to deal with the possibility that the judge might recognise that the basic or the seismic changes that have been made by 1970 legislation.
But your essential argument is it that the fact that the legislature may have made an assumption when enacting later legislation cannot alter the proper construction of the original legislation?
My Lord, yes, indeed. My Lord, the third point in relation to this is that there is no inherent difficulty with overlapping 75 Act claims and financial order claims surviving death. We submit that the 75 Act claim is part of the law of succession, and when the Law Commission considered changing the domicile requirement, it declined to do so because it needed to make sure that the test was consistent with other parts of English succession law. But there are perfectly other fields, of course your lordships will know, whereby you can have a personal injury claim and a fatal accident claim. You can have two causes of action, and of course double recovery is not permitted. There's duplication, we say, in other areas. And we referred briefly in our written case to the New Zealand approach, which is to permit an applicant to choose between one or the other by express statutory provision in New Zealand.
I mean, is that significant that it required legislation in New Zealand to bring that about?
My Lord, my submission would be that the mere fact that another legislature has made express provision for it doesn't mean that our legislation, as properly construed, doesn't give the same choice effectively in a domestic case of pursuing a financial order claim or pursuing a 75 Act claim.
So you say there's just no problem at all about these two, on the way that you're analysing and interpreting, or want us to analyse and interpret the 1973 Part 2 and 1975 Part 3, you say there's no problem with that in terms of overlap with the 1975 Inheritance Act?
My Lord, no, because under both legislation, if you were trying to bring two claims at the same time, the court would have to say, well, I'm not going to give you double because your resources that you have becoming available to you when I'm looking at the 73 Act claim include your potential 75 Act claim and vice versa. So the idea that you're going to get double recovery is nonsense. And we referred to a case in our written case called Gaines-Morphy at paragraph 58 of our written case at page 97, which dealt with a similar situation where there'd been a clean break settlement in the financial order proceedings, and then one of the parties sought to bring a personal injury claim for damages against the respondent, and that was struck out as an abusive process. So there is, we say, protection there under the existing law to prevent the wrongful attempt to pursue claims which might otherwise be duplication. My Lord, the fourth point on this point was the development of the legislation under the Inheritance Act is not inconsistent with financial orders surviving death. And I'm going to take that very shortly. I'm just going to deal with very quickly, my Lords, with the 1984 Act as well. And I've already taken you to section 95.1, and what I say was the purpose of extending the right to those overseas. Forgive me, my Lord. Yeah. And just Law Commission 117 is the report that gave rise to the 1984 Act. That, my Lords, is at tab 28, electronic file 1259. The picture is painted vividly as to the mischief of what the 84 Act is designed to do in paragraph 1.2 of that, and that's at 1262. This is the hypothetical, potentially exaggerated case of the English woman marrying a wealthy Ruritanian. There is a Ruritanian divorce. The wife has no right to apply here because she cannot bring a 73 Act claim. If the marriage is already divorced overseas, then there's nothing for the court to dissolve here, and her right ancillary to that therefore goes. And on the next page, towards the end of that long paragraph, she says she will not even have the right given to wives and former wives by the 75 Act because she ceased to be a wife, and at the time, because the definition of former wife in the 75 Act was limited to those whose marriages were divorced in England and Wales, she was not a former wife either. So this example doesn't even acknowledge the situation that the wealthy Ruritanian might in fact be domiciled in Ruritania, and therefore giving a 75 Act claim might not have done her any good anyway. But what the focus is on, we say, is on typically a wife or a spouse who might have got divorced here, who might have got access to the English courts' financial remedies, but who is beaten to it by a foreign divorce. And those individuals should have the same rights as if the divorce had happened here, no more, no less. And we say if those rights include the ability to pursue a claim after death, then same rights get given to someone applying under the 84 Act. My next point, very quickly if I can, is whether or not Part 3 is different. We say it's not. We say that the notion that an overseas applicant is somehow privileged is simply wrong, and the points we make in there are.
Sorry, what do you mean by not different? Not different from what?
Forgive me, my lord. The suggestion is made that under the 84 Act you're already divorced.
Right.
So, and the capital orders that are, we say, the ones that really do survive are lump sum orders and property adjustment orders. Mm-hmm. And I'll say a bit more about that in a moment. Now, those orders don't take effect until there's been a decree absolute. So it's the practice of many applicants for financial remedies who are in control of the divorce process as well to wait and get their financial settlement sorted or the court order made and then apply for a final order of divorce or decree absolute. And so in the ordinary case...
Interrupting. If the person dies before the decree absolute, then the lump sum order can't be enforced.
Indeed, my lord. And we say that's absolutely fine. We say that's inherent because it is in the nature of marriage that it comes to an end on death or divorce. And if it's been ended...
If the lump sum order is based on a sharing proposition, why should that be under your thesis? Why shouldn't that survive the death of the individual?
My lord, we say that there are limits to the court's ability to construe statutes, and the provisions which say that these orders only take effect on decree absolute are absolutely clear. And there's what we do say is this, that the prevailing practice is to wait to get your finances sorted and then apply for decree absolute or final order. That prevailing practice may well change if the established orthodoxy is found to be wrong. There are many people, even now, for instance, who want to get remarried and then go ahead and get their final order of divorce so they can remarry. There are people who are concerned about bankruptcy and want a divorce so an order will be effective and bind the trustee. All I say is that if the prevailing orthodoxy is overturned, it simply will lead to a different risk calculus being conducted by people who are otherwise waiting for their financial order claims to be determined before applying for decree absolute. And I say it's the nature of the particular provision. So I say that if a marriage is ended by death, then of course no court can put it asunder, because that's the nature of marriage. Likewise, a periodical payments order is an order that can only endure during the joint lives of the parties. So if one party has died, it cannot be somehow revived by a court, a PP's order, nor can one be made to begin on a date on a date which it's beyond the date it must end. So it's inherent, I say, in the nature of a periodical payments order.
But I think you're accepting that a lump sum order just cannot be made if a person has died.
My lord, yes. Right. Before decree absolute, yes.
Yeah.
So that just all I say, it will potentially alter the behaviour, and people will decide, what do I want to miss out on, a potential pension rights or the potential to my full sharing claim? And people will make that choice. And of course, if the respondent's is domiciled in England and Wales, then they, at the moment, have the safety net, and they'll continue to have the safety net. So we say there's nothing in that point at all.
I'm sorry, I've still not got the answer to Lord Legate's question. Are Part 3 claims different from...
Oh, forgive me. So sorry. I'm so sorry, my lord. From 1973 Act claims.
From Part 2?
So from Part 2 claims from
Yes.
1973. I'm so sorry, my lord. Yes, the notion is that because of that practice, that because inherently under Part 3 they're already divorced, and then they are somehow favoured. And we say that's just a matter of choice for applicants. Applicants can choose to obtain a final order of divorce if they are in control of the process whenever they want to do so. So we say it's lump sum orders, which are capital orders, and property adjustment orders, which can be made after death, and indeed they're the orders that have been made in the Barder cases. Finally, on this point, we say a pension sharing claim ordinarily would die with the death of the person with pension rights, and that's again because of the nature of pensions. Most individuals' pension arrangements on that person's death, they will no longer be entitled to the pension as such. The funds will move either into their estate or into a dependent's pension, and so pension sharing orders will go as well. So, my lords, if I can move on to issue A, are financial relief claims purely personal? We say that and there are 6 areas on this, I can take them, figuring 5 areas on this.
And just to be clear, by purely personal, you mean a claim which, as a matter of statutory construction, can only be brought
during the lifetime of the applicant. So, my lord, there are 2 sort of construction points that we make. One is the textual construction. Then there's the relevance of the sort of notion of an updating construction. And then we deal with, thirdly, the case of Dest and why the reasoning in that case is just wrong. And then we look at a couple of presumptions of parliamentary interpretation of statutes in relation, for instance, to duplication and absurdity. The simple point on the textual construction, my lord, is it's said that...
Which Act are we starting on, the 73?
Both 73 Act, 84
Right.
Act, because the powers are made in favour of or against parties to a marriage. And we've already seen Section 25 factors refer to present tense matters. And we say all of those matters, there's simply no difficulty. We've seen from the Barder cases how that works.
Section 12 at page 540 refers to, that's the application, refers to either party to the marriage, but that is in circumstances where there isn't a marriage any longer. And
My lord, yes.
a party to, must, by definition, be a party to a former marriage.
And my lord, of course, the same point might be made about any of the powers in the Matrimonial Causes Act. So, for instance, you can make an order, a property adjustment or lump sum order, on or after, on making the decree, or any time thereafter. So you can make a property adjustment order after decree nisi, or indeed after decree absolute, and the same point makes there. So I say that's one way in which the party to a marriage, the marriage may not be subsisting at the time that the power is exercised.
Well, Section 16 at page 541 are the matters to which the court will have a particular regard.
Yes, my lord. So the Section 16 factors are, should the English court make any order at all? There may have been an order somewhere else.
So
now,
those are in addition to the Section
my lord, yes.
25.
And so looking at those on page 541, we say that only really the first 3 are really present tense, and there's no difficulty, I say, with including the words, for instance, have or had with England and Wales, or have or had with the country in which the marriage was dissolved, or connection which the parties have or had with any country outside England and Wales. The rest of those provisions, we say, work, those checklist factors work just as well, regardless of whether the party to the marriage or the former marriage is alive or dead.
So sorry, you say that 16.2a, for example, can be read as have or had?
My Lord, yes. Well, forgive me, my Lord, in an ordinary case, for instance, my Lord, someone may have had a connection with England and Wales and may have left a long time ago. So there may not be a current connection with England and Wales. And I say that the same point is made in relation to someone who potentially, on account of being dead, might not be said to have a connection with any part of the world. But if one looks at the situation that was pertaining just prior to their death, one could construe that as saying, well, look at the connection they had prior to their death with England and Wales. So those factors, and the same goes for all of the other Section 25 factors. We've seen from Smith how we deal with those. Where a person
is it relevant in the way the Act's applied to take account of connections that have arisen after divorce?
My Lord, yes. Yes.
It is.
Yes.
Well, isn't Section 16.2a, isn't the same point that my Lord Stevens made, that we're dealing here with situations where there's been a divorce. The parties, therefore, are no longer parties to a marriage. So 16.2a, the connection which the parties to the marriage have, can't mean parties to a present marriage.
My Lord, yes.
But it would be parties to the former marriage
Yes.
with England and Wales.
Yes.
Yeah.
That's why I was asking whether you can take account of events since the divorce, because that suggests perhaps you are looking at the current position.
So, to give you an example on part 3, if the parties had been divorced in Russia and then they'd spent 10 years living in Russia after that and then move in year 11 to England, and then someone says, I'd like a part 3 claim, of course one's entitled to have regard to events which have taken place since the marriage, and that would impact on the connection that they have with England and Wales. So, my Lord, that goes with all of these points. There's one other point I'll make. It's on the same page 541, and that is the jurisdictional requirements. Now, they are, in essence, domicile, 1 year's habitual residence, or the having an interest in a matrimonial home in England and Wales. They apply either at the date of the application or at the date of the divorce. Now, the latter is no difficulty if one person is already dead. The second, it's the same point as I make with Section 16.2a. One can construe that, I say, purposively and say, well, if they had been, immediately prior to their death, habitually resident in or domiciled in England and Wales, the jurisdictional criteria would be satisfied.
So which section was that?
My Lord, it's Section 15.1, A, B and C are the 3 jurisdictional limbs.
And you say that under 1A, if a person was domiciled on the date of divorce but has since died, it matters not.
Indeed.
Was domiciled
You've got jurisdiction there, and then the second part of A is, or was so domiciled on the date, sorry, forgive me, it's the first part, isn't it? So the first part is on the date of the application of the leave, and if they've died by that stage, I say, if they had been immediately before their death. And the second part of it was they domiciled on the date at which the overseas divorce took place, and that doesn't offend any difficulty at all. They obviously had to be alive when they were divorced overseas.
And again, you say either the party to the marriage was or had been domiciled.
My Lord, yes, immediately prior to their death.
But if you're wrong about that, it doesn't deprive the Act of application. It just means that ground couldn't be relied on.
My Lord, yes, it has to rely on the second part of those provisions which talk about the jurisdictional criteria existing at the date of the overseas divorce. So, Lord, the second point I want to make on this is the notion of an updating construction, and we say that this really is the point that we made at the beginning. The 1970 Act, bringing in capital provision, bringing in provision that endures beyond the death of the applicant, was a singularity rather than a continuum. And my Lords, in the interest of time, I'm not going to develop that point fully, but I can give your Lordship some references to the case of Wachtell and Wachtell, and you'll see in that case, both at first instance and in the Court of Appeal, a recognition that this was new legislation, that it was not a consolidating act, and indeed learned friends appear to accept that this was a seismic change, not a continuum.
Can you give us the page references?
My lords, yes. So particularly, it starts at 3153, and the new code is referred to at 3159, and in the Court of Appeal, the judgment of the whole court, there's reference to not a codifying statute at 3172. So we say that even in 1970, the nature of provision had changed, and it really took Miller and McFarlane to make that sort of front and central and unavoidable.
So you say you don't need to rely on any updated...
My lord, no. This is a completely new statute. My lord, the next point on this, third point, is the reason why Dest, therefore, is wrong. My lord, that's the decision of Mr. Justice Ormerod in November 1972, and it is at tab 11, electronic file number 758. And the facts of that case were, and as I say, it's the only authority we say directly on point, because as we say in our written case, the case of Harb was a case dealing with a claim under Section 27 for which you need to have a subsisting marriage. The facts of that case are that the husband had brought an application during his lifetime for a post-nuptial to vary a post-nuptial settlement, being the joint ownership of a matrimonial home with his former wife. And he then died, and his widow sought to pursue that. And Mr. Justice Ormerod dismissed the application. And you'll see, my lords, at 760, that he refers back to the case of Thompson in 1896, and we dealt with Thompson in our written case in some detail, that he says that Thompson is on all fours with the present case. He also then says at 762, forgive me, opposite letter in the paragraph beginning between B and C, in my judgment. And what he does say is that the whole of the history of the matrimonial cause legislation is that this is essentially a personal jurisdiction arising between parties of marriage or children of marriage. And what we say he heard in that sense was that he overlooked the seismic change that, ironically, he had endorsed in his first instance decision in Wachtel just the month before.
This was cited with apparent approval in Barder and Harb, wasn't it?
My lord, it's my submission. Certainly in Harb, the point we make about Harb, my lord, is that the gateway to relief, either under Part 2, either under financial order on divorce, or under Part 3, is the making of a decree nisi or the existence of a foreign divorce. The gateway to relief under Section 27 is the failure to maintain and a subsisting marriage. And so we say that Harb is not relevant really to this decision. The short point in relation to that, we say, is... so let me deal with your other point, my lord. We say that what Lord Brandon does in Barder is review the authorities, look at the ratio of them, and see to distill some principles from them, without necessarily endorsing all of the decisions that were made.
Well, for my part, I have difficulty in seeing how you can distill principles from cases which you don't agree with.
Because so many of the cases, my lord, express themselves in very wide terms. And I'm probably going to run out of time before we deal with cases like Sugden. But Sugden's the case that says it's not a cause of action because it's a mere hope or contingency. But actually the ratio was about the construction of the nature of a secure provision order or a periodical payments order for benefit of children. And so I say that when one looks at what the what's going on in these cases, the very wide terms which the earlier cases said matrimonial causes a bait on death, what Lord Brandon is doing is saying, well, let's actually see what these cases decided. And I say that he, without necessarily approving any or all of them, the only one he did approve was the judgment of Lord Justice Arnold in Perth.
And at page 656, you say that he misquoted the ratio of sanctum.
My Lord, yes. So, dealing with the presumption...
So dest and dest is the only authority that you say is against you?
My Lord, yes. We say it's the only one that's on point because... and if I can just develop that point just very quickly, if one just quickly goes to Harb and...
Well, you say Harb's distinguishable because it's dealing with a different...
for your Lordship's reference, it's the judgment of Lord Justice Wall at paragraph 57 at 804. That's what he says is the short and simple answer, and we say that's exactly right, that you need a subsisting marriage. So the death of a party to a Section 27 claim will automatically bring that claim come to an end.
Which paragraph, sorry?
57, sorry. And that's 804, my Lord. So, my Lord, we say there's no duplication because the circumstances that we've already said, in which a 75 Act claim can be made and a financial order claim, which we say can be continued, they are simply not coterminous.
So in your case, paragraph 55,
my Lord,
that's page 92 to 93, you refer to 3 cases that you say would need to be overruled. Is that right? Footnote 114.
my Lord, yes. So they are cases decided under the Inheritance Act,
Right.
which say that an Inheritance Act claim dies with the death of the applicant. And we say that must also follow. If they are bringing a sharing claim to matrimonial wealth, then that also must be wrong. It's otherwise, of course, if it's one made for their maintenance, because maintenance under the Act only continues during their lifetime. But, my Lord, the 2 presumptions that were in play, potentially a presumption against duplication, we simply say it's not engaged. There's no duplication. There is an overlap, of course, but no actual duplication. And my Lords, we've set out in our written case, the various anomalous, irrational, or illogical results that the established orthodoxy gives rise to. For your Lordship's reference, there in paragraphs 42 and 52 of our written case. And we say, far from creating anomalies, overturning the established orthodoxy would avoid those anomalies and injustices, and it will avoid the post-death barter provision from being seen as either anomalous or too difficult to think about. So I've taken that rather quickly. On this point, the statutory construction point, whether the Acts 73 Act and 84 Act is properly construed, whether those rights are purely personal, in relation to that, my Lords, we say that they're not, and we say that the conventional orthodoxy, in Lord Bingham's words, was in fact highly questionable already in 1972 when Dest was decided, and by the time we get to 2006, once we've had Barder cases, once we have Miller showing the way in terms of how the jurisdiction should be exercised, we say the orthodoxy had become unsustainable. My Lords, dealing very quickly, if I may, then with the last issue, which is the whether or not it's a cause of action for the purpose of the 1934 Act. We say this again, it's a sort of rather odd issue in the sense that if they're on the proper construction on issue A, they're not purely personal, then it really sort of falls away. But in our written case, what we did was analyse the nature of the cases that did not survive death prior to the 34 Act. Not just claims in tort, but any unliquidated claim, and anything which involved the performance of a personal contractual obligation. And we say, with the benefit of hindsight, don't they look very similar to the nature of matrimonial claims? You haven't got a liquidated claim until the court makes an order and proves as it were, decision on quantum. They're personal because the provision at that time could not endure beyond lifetime, because it was only periodical payments, which ended on the applicant's death.
You say if they're not personal, this issue falls away.
My Lord, yes.
But doesn't it equally fall away if they are personal?
My Lord, I suppose I'd say that the 1934 Act is it's all-encompassing. It refers to all causes of action. And unless there is a reason to limit it, we say it will include this cause of action as well. And the argument that it's discretionary, already debunked by Lord Justice Hodson 10 years after Dipple in Sugden. He's already rowing back to that himself. And both Lord Justice Thorpe and Lord Justice Dyson in Harb had serious misgivings about that nature. And we say the other point is it a mere hope or contingency? The very fact that a claimant for a lump sum order or property adjustment order can charge that claim in favour of her solicitor under a Sears Tooth arrangement or in favour of litigation funder, we say that is the very definition of objective solidity, that it's a cause of action that would survive the applicant's death. So this notion that you don't have a cause of action until the court's adjudicated upon it, we say doesn't appear in any other form of cause of action.
It's a somewhat unusual cause of action because you actually have to have commenced proceedings, because you're not suggesting, if I understand you correctly, that under the 1934 Act, you could commence proceedings against an estate.
My Lord, I am. I say it's both an unadjudicated claim and one which is yet to be brought, because there is a right...
If the person has died before...
Well, that's the same point we've been making in relation to the 1984 Act, and I was saying that the jurisdictional criteria would be met if the person had died before the claim was made, because otherwise it would be a windfall to the estate of the respondent.
So you get divorced 1 year, you're entitled to bring your financial relief 10 years later or 30 years later. The person in the meantime has died. You can bring a claim against the estate.
My Lord, yes. And I say there's no difficulty in relation to that. I mean, at the moment, my Lord, there are about 120,000 divorces a year in England and Wales. There are about 30,000 financial remedy consent orders. So there's a large cohort of people out there who get divorced but don't have an order dismissing their claims. The courts are not swamped with claims made many years after the parties divorced during their lifetime. They won't be swamped by, claims made after the death of one of the parties in these circumstances. And if they are, the remedy is already there under the existing law to deal with delay, and that's the case of Vincent Wyatt, which we refer to in our written case.
How does that read into the Section 25 factors? Then, if on that scenario you have a claim against the estate, say 10, 15 years later, the person in the meantime has died, how does that work out with the Section 25
My Lord,
factors?
you apply the same adjustments that were applied in the Barder cases in Smith. You obviously, a dead person cannot have income and earning capacity, a dead person cannot have financial needs, but they can have made a contribution during their lifetime to the welfare of the family. And the 1970 Act was designed, as Lord Denning says in Wachtell, to remedy the injustice that those contributions were not being recognised.
Can I ask you, because I think you may be coming, shortly to the conclusion of your submissions. A point that bothers me is, even if we were to be with you, is this the sort of reform that is so radical that one ought to leave it to the legislature?
My Lord, it is simply, I say, a matter of construction. Exactly the same argument was made in Dart, my Lord, that the reasonable requirements case law, well established. We're not going to have anything like 50-50 division of assets in this country. There was parliamentary, or there was government consultation. That's entirely a matter for Parliament. 4 years later, overturned, my Lord. And so I say it's exactly the equivalent situation. House of Lords in White felt that they were able to sweep away those the prevailing orthodoxy in that case, and we say this court need have no fear of doing the same in this case.
But coming into this case, it's not as if, or you may correct me, but have we got any sort of calls for this sort of reform? I mean, clearly, Mr. Justice Mostyn is taking that view, but where do we find any other call for reform, whether from a law reform body or indeed academic journals or anything of that kind? Or
the short answer to that, my Lord, is I don't know. I would say that everybody who practices in this field will have had experience of advising someone in Mrs. Hassan's position, and have no doubt given advice as to what could be done in a court below this court, and the issue is there for construction. I invite your lordships to decide it on the points we've made.
The adverse effects obviously apply, or potentially apply, in the factual circumstances of this case. What other examples can you give?
My Lord, forgive me, they're the ones that I skipped over for want of time, but if I can just quickly go back, they're the ones I referred to at paragraph 42 and 52 of our written case. The notion that Mrs. Richardson was fined because she got her order before dying, but potentially wouldn't have had anything at all if she had died the week before. Okay, Mrs. Richardson may have had a chancery claim, but perhaps another Mrs. Richardson might not. Forgive me. The most sort of vivid example I can give you, my Lord, is the notion that when the judge at a financial dispute resolution appointment approves a settlement and says the words "I approve," there's this notion of the unperfected order that comes into being. Now, it is said that that order is sufficiently perfected or real that it will, at the moment, give rise to a perfected cause of action, and if there was decree absolute, that person would, even if the husband died walking out of the court, be able to get something. But if he died walking along the corridor into court, she wouldn't. And so we say those are the sorts of examples we say where there are anomalies and injustices.
I mean, under the Inheritance Family Provision Act, she would be entitled to bring a claim.
Only if the respondent's domiciled in England and Wales. And as we've seen, my Lord, there is this succession law insistence that in order to bring that claim, you have to be domiciled in England and Wales.
Is that the only lacuna?
Forgive me, my Lord, in what sense?
Is that the only thing that causes the injustice?
My Lord, forgive me, I'm just going to have to think about that. Well, it might be. That's all I can say at the moment. You put me on the spot, and I'm doing my best to think of other circumstances, but at the moment I can't. I may come back to that in reply.
You can come back to that in your reply submission.
So, my Lords, in conclusion, if I may, this appeal has, to some extent, a case of pure law, but of course it isn't. It's a case of justice for Mrs. Hassan and now her estate and the individuals in her circumstances. She first sought to get her fair share of the assets of this marriage, a long marriage of over 25 years, in 2009 by bringing proceedings. The divorce took place overseas in 2012, and that prevented her from bringing a claim under the 73 Act. She obtained leave to apply under the 84 Act in August 17, and the court will know from it's not an agreed chronology, but it's there in the appendix what happened in that litigation after that, and there was non-disclosure, non-compliance with court orders, and hurdle after hurdle, which she seemed to surmount, only it seems on the face of it to fall at the final hurdle with the death of Colonel Ul-Hasan in January 2021. And we say that that's an injustice to her, an injustice now to her estate, a windfall to those otherwise entitled to Colonel Ul-Hasan's death. She is, I say, she's not alone, or wasn't alone. There are, I say, a significant number of people like her. And if I can, you can forgive me with another well-researched quote about heresy and orthodoxy. A 19th century American lawyer said, "Heresy is a cradle, orthodoxy a coffin." And my lords, I invite you to bury the established orthodoxy and to give birth to this new understanding of our legislation, which will banish the illogical, arbitrary and unfair outcomes that I have set out in our written case in my submissions. Lords, those are my submissions.
Mr. Horton, thank you very much. You've eaten slightly into your reply time, but I did give you another few minutes because of the adjournment. But you've probably eaten into about 4 or 5 minutes of your reply time. I would be grateful when you do reply if you address the respondents' submissions on the effect on insolvency law.
My lord, of course, yes.
Thank you. Mr. Amos.
May it please the court, the submissions which I made together with Madame Julius, Mr. Charsley and Mr. Raymond, of course, are made for the respondents, principally on behalf of Miss Lamia Al-Shaiba, the widow of the deceased first respondent, Mahmoud Al-Hasan. The court will be clear, but I emphasise that as a matter of formality, there is absolutely no acceptance of the critical comments made against either Mahmoud Ul-Hasan or against Ms. Al-Shaiba in the Appellants case. Ms. Al-Shaiba is present remotely, my lords. Her childcare arrangements prohibit her being present in person. But this, my lords, is a case, we say, about what the law is, and not what it might be under a different legislative regime. I'm very sorry, I've had that instruction before, I've ignored it already. No, I'm very comfortable. Thank you very much. My Lord, therefore, pursuing the submission that this is a case about what the law is rather than what it might be, the respondent's case, our written case, makes the submission to your lordships at paragraph 7. It's electronic page 108. But at paragraph 7, we say that there are essentially 4 errors of approach in the appellant's case. The lack of consideration of parliamentary intention, the lack of attention to statutory construction in relation to the 1984 Act, which is the governing act for the application about which this appeal is taking place. The, as we say, mischaracterization by the learned judge below and by the appellants in their case to your lordships, the mischaracterization of the Barder analysis, and fourthly, the absence of analysis in relation to the context of the 1934 Act, if, of course, that Act is of any relevance to your lordships' analysis, which we invite your lordships to say it has no relevance, because under the sequence of questions which Lord Brandon identified and formulated in the Barder case, and which both sides, in this case before your lordships, appellants as well as respondents, agree are the foundation for any analysis. Under those three questions formulated and posed by Lord Brandon in Barder, the analysis does not get as far as the third question, namely the role of the 1934 Act.
But doesn't the 1934 Act, if it applies here, establish the default position, which then the legislation has to show some intention not to contract out of, so to speak?
Well,
that is how, for example, it's been analysed in relation to race discrimination claims, where the language of employee is used, and you might think, well, that's a personal claim, but the court has approached it on the basis that it's a cause of action that prima facie survives death under the 1934 Act, and you'd have to find some contrary intention in the Equality Act.
Well, my lord, with respect, that presupposes that the claim at the base of the present case is indeed a cause of action.
Well, of course it does, but you were saying that one never gets to that, and I'm saying that if the claimant, if the appellant is right on that, what you say is the last question, then that colours the approach to what you say is the first question.
Well, Lord, of course, with respect, I see the force of your lordship's point, but under the sequence of questions which both sides agree is the right approach in this case, namely Lord Brandon's three questions in Barder and Kaluri. You take question 1 first, question 2 second, and only if the answers to both of those questions are in the affirmative do you proceed to his third question, which relates to the 1934 Act.
That's just an assertion that Lord Brandon has said that, but what I want to know is what is the logical analysis, and why isn't it that if the 1934 Act applies, then prima facie the claim survives unless a contrary intention is expressed, whereas if it does not survive because it's not a cause of action prima facie, then you probably don't need anything more than that. But you'd have to, then it would be for the appellant to be arguing that nevertheless, on the proper interpretation of the matrimonial legislation, it is intended to survive.
Well, we say, and I will develop this, I anticipate a little more after the short adjournment, but we say that the contrary intention that your lordship is looking for with respect is very clear indeed and very clearly expressed, and that when looking at the reasoning, but even more importantly the intention that the legislature expressed in the 1984 Act, that the position is firstly absolutely clear. Secondly, we say perhaps of course absolutely right, but in a sense what matters more is its clarity of expression, and we say that the position in 1984 in relation to the 1984 Act expresses a very clear intention on the part of the legislature, which incorporates a very long established orthodoxy and does so very deliberately as well as very clearly.
Thank you. Well, you rely upon Section 12 to establish that, and the words parties to a marriage, but properly construed, that must be parties to a former marriage, wasn't it?
Well, Lord, with respect, not quite, if I may say so. And that is because if one goes to Section 12, and it's the point with respect to your lordship raised with my learned friend Mr. Horton, that when Section 12 is, sorry, I'm just getting up the right page again. It's electronic 539 is where it starts, of course, as your lordship said earlier. And Section 12 has the two parts conjunctively. A marriage has been dissolved or annulled, or the parties to a marriage have been legally separated by means of judicial or other proceedings in an overseas country. So a foreign divorce, whether proceedings or otherwise, for present purposes. And B, the divorce, annulment or legal separation is entitled to be recognised as valid in England and Wales. The second condition concentrates on the recognition under English law, and it does not, with respect, require a consideration of whether in fact the marriage in question is valid, but rather as the policy of the 1986 Family Law Act, whether it is entitled to recognition. For that reason, in my submission, it is entirely logical that the use of the term marriage is a neutral term, neutral as to timing and validity, precisely because there would be circumstances in which the marriage, although entitled to recognition in England and Wales as valid under the 86 Act, might have some other questions as to its validity for other purposes.
You mean divorce, not marriage, then?
Forgive me, I'm very grateful, yes. Thank you very much.
But it must at least, either party to the marriage, which are the words that then continue, must at least include situations where there has been a valid divorce.
My Lord, yes, with respect.
So either party to the marriage cannot mean a marriage now valid.
That necessarily subsists.
Absolutely. With respect, I entirely accept that it cannot mean that that the marriage necessarily still exists.
Which I think is the only point being put to you. That it therefore can include a situation where the marriage has been terminated by death.
But with respect, that is separate from the question and from the use of the present tense, as we will come to in a moment, particularly by reference to section 15 and then 16.
Before leaving section 12, I just assumed that either party to the marriage could only refer to people who had already been divorced, and the divorce was recognised in a foreign country, recognised in this country. It could only be people who had been parties to a former marriage.
Well, with respect, that may well be so in many, if not most cases. But with respect also, it is because it is not the function or the focus, in my submission, of this part of this section to look at the validity or otherwise or continued subsistence of that marriage. What is, in my submission, the focus here is the geographic location of the marriage or its termination.
But do you accept that you cannot infer from the use, simply from the use of the expression party to the marriage, that the Act is only intended to apply to people who are alive?
In relation to this particular section and in relation to the question which your Lordship is driving at, yes, I accept that. But with respect, when one carries on in the same Act, and particularly looking at the scheme of the Act, you'll see that in subsection 3 of section 12, the words, "For the avoidance of doubt, it is hereby declared that the reference in subsection 2 above to remarriage includes a reference to a marriage which is by law void or voidable." So that again, one is not, or the Act in my submission is not, for these purposes and at this stage, concentrating on validity, precisely because it is taking the focus away from the validity of the marriage and looking at the entitlement of that divorce, annulment, or legal separation, the entitlement of that to recognition under the law of England and Wales. And that particularly is by reference to the Family Law Act of 1986, so 2 years after the Matrimonial and Family Proceedings Act 1984. The 86 Act sets out a codified provision for, in fact, all of the United Kingdom in its different parts as to the circumstances in which it will recognise as valid a divorce obtained outside this country. It's one of the relatively few areas, if I may say so with respect, where family law within the United Kingdom is dealt with at a state level as distinct from the usual division between, for present purposes, England and Wales and most notably Scotland. But turning, if I may, therefore, as it's convenient, if it is to your lordships, to the sections that follow, the scheme of the 84 Act, the scheme of Part 3 applications, is that as my Lord Stevens has already observed, the leave requirement in Section 13 is a pre-requirement, and it is in the two senses that the leave of the court has already been obtained, and the court shall not grant that leave unless it considers that there is substantial ground for the making of an application. Your lordships have seen already from our case that we say that the leave requirement in itself is an important distinction from a straightforward cause of action. And I'm really here addressing my Lord Legate's question to me earlier. But I emphasise that the leave requirement has itself two aspects contained in this Section 13.1. And as your lordships see from Section 13.3, the leave under this section may be granted subject to such conditions as the court thinks fit. Then when one comes to Section 15 of the Act, and this is now on electronic page 541, the jurisdictional provisions are set out in 15.1 A, B and C, and they are disjunctive alternatives, but nevertheless, as your lordships see, 15A, either of the parties to the marriage was domiciled on the date of the application, B, was habitually resident for 12 months on that date, and then C, had, at the date of the application for leave, a beneficial interest in possession in a dwelling house. And that is the residual jurisdictional base for a case where the parties have no habitual residence, no domicile here, but nevertheless a matrimonial home. And in those circumstances, the quantum of the claim is limited, in effect, to the equity in that home, as I will come to in a moment.
On one interpretation, all of those point to a living person, apart from A, the second part of A, because you could be domiciled on the date on which the divorce was obtained, and you could die.
My Lord, that I entirely accept.
Which is this case.
Save for the location of the domicile.
Yeah. Yes.
But as to chronology, I accept.
Well, no, he was domiciled in Pakistan
Yes.
after his death.
Exactly.
Yeah.
So that at no stage was the respondent's domicile in issue for the Part 3 application. The respondent's domicile, with respect, is principally of relevance in relation to the Inheritance Act claim, which otherwise the appellant would have been able to bring.
But on the plain reading of this section, the appellant is in under 15A.
Yes, certainly that would be her case, and perhaps less controversially, she would say, in any event, habitually resident for more than 12 months. The relevance of the tenses in my submission is that when your lordships travel on to section 16, again the tenses are deliberate and expressed. 16.1 is the second filter, in the sense that it is the duty of the court to consider whether England and Wales is the appropriate venue for application. So it's a connection filter. And as your lordship sees, it reads, before making an order for financial relief, the court shall consider whether in all the circumstances of the case it would be appropriate for such an order to be made by a court in England and Wales, and if the court is not satisfied that it would be appropriate, the court shall dismiss the application. And again, we say with respect, returning to my Lord Legate's question to me earlier, this immediately takes Part 3 applications a long way away from a cause of action in the sense of entitlement.
Does it? Because isn't this concerned with venue, as it says? So it's rather like an argument about forum conveniens. I know it's been held not to be forum conveniens, but it's a different test. But it's a similar sort of thing. You're deciding whether England is an appropriate place to have the application. That doesn't tell you anything about whether the claim itself is a cause of action or not.
Well, save my lord with respect that it involves an evaluative approach that at least conceptually might produce a different result on the same facts from two different judges.
But so, for example, there's a forum conveniens test where you're arguing about jurisdiction in a contract claim, but it said that a foreign court is a more appropriate forum in which to try the action.
My lord, with respect, yes, but again, with respect, I would venture the suggestion that that is not a constituent part of a cause of action.
Exactly. So that my point is that this isn't telling you anything about whether the financial order claim is a cause of action. It's simply telling you about whether England is an appropriate forum in which an application can be brought.
With respect, I would urge on the court the view that in terms of entitlement or otherwise to relief, it puts any applicant a further stage away from being able to say, this is my entitlement, here's my cause of action, this is my entitlement. And this was the matter that was considered most authoritatively, most recently, in the case of Agbaje, which your lordships have at tab 6 in the cases section. Just before I leave section 16, and I'm conscious of the time, the very last subsection is the length of time which has elapsed since the date of the divorce, annulment, or legal separation. That is one of the factors that the English judge has to take into account in applying the section 16 connection test. And then one moves on to section 18, in deciding whether to exercise its powers, and if so, in what manner, the court takes into account and is required to the factors in section 18 which mirror, it is right to say, the section 25 factors in a domestic financial remedy case. But your lordships will also see at 18.6, where an order has been made by a court outside England and Wales for the making of payments or the transfer of property by a party to the marriage, the court, in considering, in accordance with this section, the financial resources of the other party to the marriage, shall have regard to the extent to which that order has been complied with or is likely to be complied with. My lords, finally, and again, I'm conscious of the time.
Am I understanding your submissions to be here that on a textual analysis, these provisions cannot apply where, to the facts of our case, where one of the parties has died?
Lord, yes.
Well, why can't you apply 18.6 perfectly straightforwardly?
And what I would be saying is, at the moment, I'm struggling to understand why any of these examples that you've given are necessarily ones that can't be applied to our situation. It may be that background considerations would lead you to believe that that's not the best interpretation, but in terms of just the textual analysis, it looks as if these provisions can be sensibly applied.
I wonder if that is a matter that you could return to after the short adjournment.
Certainly, my lord.
Thank you very much.